Good afternoon. It is our high honor and privilege to present to you three gentlemen who probably have had as much to do with e-discovery and e-disclosure as anyone you have probably ever met. You really cannot talk about e-discovery in the United States without talking about the Honorable Andrew Peck, and you can't talk about e-disclosure without mentioning the Honorable Stephen Whitaker, as well as the gentleman from Oxford, Chris Dale. I'm David Horrigan, the eDiscovery Counsel and Legal Content Director at kCura. I helped the kCura Relativity team put together some of the legal content you see on the Relativity blog, what you see at Relativity Fest, and some of the white papers we put out, the Case Law Year in Review, shameless plug. I'd encourage you to read it. I hope you get some good information from it, and I hope you enjoy the programming and learn something from what we do and have a little fun in the process. Starting at the end, a gentleman who needs no introduction, Chris Dale, the founder of the eDisclosure Information Project. You've probably seen him at Relativity Fest before. You may have even heard him this afternoon in our international session. He's an English solicitor, Oxford alumnus, and he is an institution on the legal technology circuit. Please welcome Chris Dale. Next to me, as I mentioned, is the Honorable Andrew Peck, United States Magistrate Judge for the Southern District of New York. He is known to many of us as I've said before, the grand poobah of technology-assisted review. He handed down in 2012 the De Silva Moore decision, which was in essence the Marbury versus Madison of technology-assisted review, really got the ball rolling. He has followed up with numerous decisions. You know, it's not treatises and treatises like you would see on a slip and fall in a grocery store or a car wreck case, but as far as technology-assisted review and e-discovery goes, he has put out more thought-provoking jurisprudence than just about anyone. Please join me in welcoming Judge Peck. And finally, but certainly not last, the Honorable Stephen Whitaker, former Senior Master of Senior Courts of the Queen's Bench Division. I mentioned that you can hardly mention e-disclosure without mentioning Stephen Whitaker. He's known for the Practice Direction 31B, and I might add that Chris Dale joined him on that project. He also was a really important driving force in making sure that asbestos cases were handled in a fair manner, and he's known by many of you in the United Kingdom for his contributions to the bench. Please join me in welcoming Stephen Whitaker. You'll see our agenda in front of you, and as you look at this thing, there are sacrosanct topics. They're just bam, 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 1, 2, 3. You're going to find during this presentation that they sort of meld together, perhaps most notably technology-assisted review and proportionality, because they tend to go together. Sometimes, as we'll find out, even cooperation goes. I'd like to take a brief detour for a minute because I may have learned something today, and frankly, those of us from the United States may have learned something. With one of our rules in the United States, Federal Rule of Evidence 502D, we've done the Peck poll, where Judge Peck polls the audience to see what lawyers have actually implemented the rule, or more importantly, even known about it. Today,
and the result here, with almost everybody being from the UK, would get me about as many hands using it where the rule doesn't exist here as we still get in the United States 7 years after the rule was adopted, which is a scary thought.
Sadly, he's right, of course. This one is a little bit more lighthearted. It involves the seminal United Kingdom case of England and Wales in, is it Piro or Pyro? We have the Piro-Pyro poll. Those of us in the States always say Piro, but I have heard multiple very accomplished speakers say Pyro. Show of hands, is it Pyro? We've got some Pyros, and that doesn't mean you're going to burn down any buildings anytime soon. How about Piro? Boy, we Americans are relieved. Piro seems to have won, but we do want to get that cultural sensitivity going. Because
we did go through something very similar. One of the seminal cases was Judge Shinlin's decision in the United States involving Laura Zubalake or Zubalaki, depending on how people pronounced it, till they finally learned, when she went out on the lecture circuit herself, that it was Zubalake.
A profound contribution to the nomenclature. The first thing we'd like to do is do a brief overview of e-disclosure and e-discovery. And I say brief because we've got a very educated audience here. You know a lot of this stuff. But very briefly, we'd like to talk about defining e-disclosure versus e-discovery. Chris, I know you've got some thoughts on that.
It's a difficult one because, at one level, it doesn't matter what you call it. It does matter in one context, which is the rules of civil procedure in England and Wales, which refer expressly to disclosure as opposed to discovery. That was one of those changes. If you think back to 1999, everybody was changing the name of things under the impression that that made them better. And disclosure was or discovery was no exception. There was no logical reason that was visible to me anyway for changing the name to disclosure. And it happened just at a point when the emphasis was moving towards discovery, towards uncovering what you get in ever larger volumes. It also happened just at the point when it became an international subject, when we started sharing information about it. So to have our own special name for it was distinctly unhelpful. The rules in all sorts of countries that still call it discovery share similarities between our so-called disclosure and the US discovery. It doesn't matter a hoot, frankly, as long as when you're talking about the civil procedure rules of England and Wales, you use disclosure.
Excellent. Another cultural chasm that we're going to try to bring together is data privacy and the different reactions to it. And obviously, when you're doing e-disclosure, e-discovery, it's an important issue because by its very definition, you're going to involve very sensitive personal information or personal information. Stephen Whitaker, do you find that when you talk to people in the United States, the attitudes on data privacy are far different than you've experienced in the United Kingdom?
It would be an understatement to say yes. Data privacy, what's that? Perhaps I'm mispronouncing it. Perhaps it should be privacy. No, I think there's a tremendous difference, and I think a lot of Americans are quite convinced that their own government spies on them all the time anyway, so what's the point? The real problem, of course, is for us Johnny foreigners who don't want to send private material to the States and think that it actually could be open to view by many, many people that it shouldn't. So, yeah, that's the answer.
Any disagreement with that? I don't think we're going to find any, but
There's one expansion of that.
please.
We tend to think of this as being a problem that arises when we send data abroad and specifically to the US. We are actually supposed to have regard to personally identifiable information and discoverable information locally, anyway, within the jurisdiction. And if you want chapter and verse on that, 2 years ago, 3 years ago, the Information Commissioner's Office had a go at a firm of some lawyers because they'd handed over a whole load of data on disclosure that was stuffed full of PII, which they hadn't looked at. That set of lawyers happened to be the Treasury solicitor, who got wrapped over the knuckles for that.
But they hadn't handed it over, Chris, in the context of disclosure within litigation. They'd handed it over for other reasons.
Yes.
They had a lot of files. Somebody, I can't remember the exact context now, needed to see them, and they handed them over without any thought as to the data privacy implications. Now, it may seem incredibly surprising that the Treasury solicitors did that. For those of us who worked with the Treasury solicitors for 7 years, in my judicial job, it didn't seem too much of a surprise. But the fact of the matter is that we're all guilty. I mean, you go back 10 years, nobody cared a tinker's cuss about data privacy. People
Expletive deleted.
just didn't think about it at all. But, you know, things have had to change enormously, and when the GDPR, which sounds like an East German republic, comes in May next year, we'll have to think about it much more seriously. I think of more importance in some respects is the proliferating use of the letter E in front of everything. Chris has heard this a million times, so he'll have to hear it again. When I told a colleague of mine in the Queen's Bench Division some years ago that I was giving a talk on e-disclosure, his reaction was to say, I distrust any word that has an E in front of it. I thought, oh my God. And that attitude, I'm afraid, continued for a very long time. And I think there's still a certain amount of a frisson when lawyers and professionals are told that it's very important, eDisclosure is very important. Oh, well, it's not really this. It's very much the same as paper, isn't it? I mean, you do the same process and all the rest of it. Well, no, you don't. And we've discovered that now, I think, particularly because of cases like Pirro and David Brown and BCA, that there is another way of looking at this.
On that topic, Judge Peck, in your courtroom, can we just drop the E because everything you see, all the data that comes in is pretty much electronic?
Yes. I mean, I think a number of cases where there is still paper at issue is minimal. And so it is discovery or disclosure, and yet we still refer to it with the E. And, it's getting to the point. And for those who hate e-discovery and say, well, why don't we do away with it? I mean, that would be doing away with discovery, disclosure, whatever you're calling it. It just, there are very few cases where it's not electronically stored information that's involved. And as the technology changes, whatever handle we're getting on data through use of predictive coding or anything else, the technology is also proliferating on the type of data that there is that could be relevant and proportional in discovery, whether it's Facebook information, whether it's voicemail, Dropbox, et cetera, et cetera, et cetera.
There's a case for keeping the E, if I may make it, which is that for Google searches and the like, discovery is a word that has all sorts of meanings, whereas e-discovery tends to be limited to the subject that's of interest to us.
But then is it with a hyphen or without a hyphen
when
you do the search?
Too much.
But if you've got paper, you'd be a fool now if you don't OCR it. The OCR is so good now. And you just turn it into electronically stored information and then put it in with the rest. And that's the common advice.
It would appear that former Senior Master Whitaker is advocating for creation of more big data almost, which is an excellent segue into our next topic.
If you're faced with half a warehouse full of paper files, what else you do? It's very low cost to get someone standing in front of a machine that OCRs it and then use tar on it or whatever, than actually saying, oh Christ, we've got to have 100 people reviewing this eyes on. You just wouldn't do it, would you, if you had any sense?
It won't surprise you to know that there's at least one case where the question has been considered, is paper that has been scanned electronic information that is therefore subject to Practice Direction 31B? The answer is yes.
Yeah, of course.
But it has come up for judicial consideration.
Until very recently, there was a U.S. District Court in the United States that had as its official policy, scan the paper and then give us the electronic files. So we create more big data. But on proportionality, it was one of the biggest issues in the 2015 amendments to the Federal Rules of Civil Procedure in the United States. It's also been a big issue in the United Kingdom. I don't think that I'm going to get any debate on this question, but maybe I might. And I want to tell you that we are very grateful to our English hosts. We are not trying to relitigate the Battle of Yorktown or the Boston Tea Party, but we do have two Americans and two members of the English bar here, and I wanted to ask a question on proportionality. Who got there first? Judge, I mean, we've had cases in the United States that date back decades, bringing up the issue at least.
Yes, but, as much as I'm a firm believer in America first or whatever.
Are we great again?
We are great again. But let's not go there.
You have to be a bit careful about that now.
Yes,
That was in air quotes, by
although,
the way.
The great thing, I'm always worried about, I'm going to say something lightheartedly and nothing is off the record. Thank goodness in this panel, the two people who tweet about my comments the most, Horrigan and Dale, can't get to their tweeting application while we're doing this. But,
you want to bet?
but, technically, We put proportionality into the rules in the United States in 1983. And then in 1993, it got moved down. And this is one of these, if the rules are too long, are people going to read them? So it moved into 26B2C Romanet 3. And as you could tell from the way I'm saying it, it was ignored completely. And in December 1, 2015, the rules amendments, proportionality got moved back to 26B1, right at the definition of discoverable information. It is in some ways what I called, the PR change, the product where the box says new and improved, and the cereal is the same. The box is prettier, and that's what's new and improved. But it wasn't until then that people focused, including judges, on the proportionality factors. And there have been more judicial opinions since December 1, 2015, talking about proportionality than there were in the 30 years before that. So technically, maybe we came first, but realistically, sorry, David, we were late to the party.
And I suspect that the gentleman from England and Wales will certainly agree with the judge's assessment.
Yeah, I mean, there are a lot of surprising facts about English civil litigation. One, for example, like the fact that we didn't do postal service in the High Court until 1976. I mean, you wouldn't believe it, but we didn't. Proportionality. I became a sitting deputy district judge on the day that the Wolf reforms came into effect, even though 6 months earlier I'd been trained entirely on the old rules. You'd have thought they could have foreseen that I might need a slightly different form of training. But the point about Wolf was a judicial review practitioner. Proportionality was his thing. And you look at the old rules, the original Wolf rules, proportionality screams out of them. But Rupert Jackson had to enhance that, particularly in Rule 1, which was universally ignored anyway. But more particularly, and much more importantly, in Rule 44.3, the enhancement of the effect of proportionality on costs and how they're assessed and how they're budgeted. So the surprising fact is, I don't think in the English procedural rules before the Wolf reforms came into effect, proportionality was anywhere. So we are talking about 1998, or was it 9? I can't remember now. Too long ago. 9, yeah.
Well, we're not really talking about who was the first to get the word into the rules, are we? We're talking about whose practice. It doesn't really matter, actually, whether it's whose. The practice of, certainly in England and Wales, has been to adopt proportionality increasingly as the years have gone by, whether expressly or not. Perhaps Jackson's reforms of 2013 were the biggest single push in that direction, not least by emphasizing costs. What is proportionality? Well, it's the balance between the risk you're going to miss something, the amount of work that has to go into it, and the cost of doing it, and the justice you're going to get out of it. All those components are sort of mixed in to proportionality. The Jackson, I said at the time of the Jackson reforms that we'd look back and say they're not big and new and special. They're a logical progression from 1999 through the Whitaker practice direction and through into Jackson. They all build on each other. And with each step, proportionality became an important concept. Now we're finding it referred to, we jolly well should find it referred to in most judgments where judges are trying to weigh the scope of disclosure.
Stephen Whitaker, at the time, shortly after the Jackson reforms, I believe it was in 2014, the Law Society came out and said that the Jackson reforms posed a quote-unquote serious risk. I assume that you disagree with that analysis, that you found the Jackson reforms to have a positive effect?
Yes, because the emphasis effectively was on getting costs down. How could you argue against that? The only problem was going to be whether, in fact, to get the cost down, you were going to make people do more work, which was actually going to be pushing upon the other side. I mean, one of the real problems that we've had since the Wolf reforms came in is the temptation for successive rules committee to keep adding incrementally little bits to the rules, giving fee earners, who are the people, of course, who spend the time, which is then charged, more to do. And I was very unpopular at times in the Rules Committee over the 6 years hard labour I had to do on it. Because I was always the one who put my hand up and said, well, do we really need to make another rule that they've got to do another witness statement on this? Oh, but it's only another witness. It's only a witness statement. Yeah, but you've got to add it to all the other 10 or 15 or other that they're going to do. So there's always an upwards pressure as well as a downward pressure. And I think some of the things that happened in the Jackson reform, particularly with costs management, have pushed up costs to some extent, even though, you know, the idea was, oh, well, you will limit the amount of money you can have for doing your budget and all that sort of thing. It doesn't quite work as easily as that. So I was worried that cost budgeting would not have quite the remarkable effect that it was supposed to have. And I'm very interested to see now that there is proposed to start shortly a pilot on fixed costs in claims up to £250,000 value. Because the story is one you'll all recognise. When it was cost management, the pilot was on defamation claims in my court. It was done as a pilot, but we all knew perfectly well when you got to the end of the pilot, it was going to happen. And the same, I suspect, will happen with fixed costs up to 250,000. It's a pilot in the Mercantile Court in London and in Manchester and the Specialist Courts in Manchester. And when it's finished, sure enough, I suspect we will have fixed costs up to 250,000. And then the time will come, as was happened with cost management. They didn't do it in the commercial court, but then somebody decided, well, you know, we've got to extend this. And the time will come when it will become much, much more prevalent throughout the system. So my sneaking suspicion is when you read the articles about it and you see Rupert Jackson saying, well, you know, we had to think about this because there were a lot of pre-budgeting costs that weren't being taken care of, and he gives the percentage figures in the different types of litigation. I'm not so sure that's really what's at the seat of it. I think at the seat of it is the fact that there is still quite a belief amongst senior judiciary and the government that the costs are still not being kept down anything like as much as they should be. And so that in the end of the day, fixed costs will be, you know, rather like the German grid system, will be the answer.
Chris, I assume you're in agreement with pretty much most of that?
Yes, I think the point that gets missed, perhaps, is that if you take something like fixed costs, the definition of what is proportionate is going to change. If there's an absolute cap on what is to be spent, then people are going to have to look again at what is proportionate for this case. They're going to have to look back at old rules, like Rule 31.7, for example, the scope of the search, and redefine their idea of what that search ought to be to fit the new cost climate. And that means perhaps taking shortcuts. That means perhaps not looking in places you might previously have looked in. But this time, not because you're negligent or forgetful or don't feel like it, or because you fear what's there, but because there is an absolute bar on your spreading your net too widely. And if you have the sort of authority that you get by saying, we didn't do this because, then you're covered effectively. It doesn't help if that was in fact where your own secret missile lies. But in terms of the scope of your duty vis-a-vis other people, looking back at some of those old rules is going to be something we should be doing more of.
Sure. He's going to give a big push to the use of technology.
Yes.
Which is, as far as I'm concerned, a jolly good thing.
We're all glad to hear that, I assume, correct?
Well,
because people are going to have to start looking early.
yeah, they have to look at cheaper ways of doing things.
To go to the case management conference already equipped with the solution that any technology can give them as to what have we got here?
Yeah. I mean, you asked the whole question about... I mean, I remember attending judicial training sessions when people would ask the almost rhetorical question, but it wasn't actually, because people started giving answers to it, which is, what would you regard as proportionate if you had a claim worth £250,000? And there were people who were actually saying, oh, well, I suppose it would be proportionate to spend up to £250,000. Yeah, yours truly was sliding under the table at this stage. I mean, and I would come back and say, look, it cannot possibly be proportionate to spend more than £25,000 on a £250,000 claim, and that's giving it some welly as well. So you know, fixed costs will effectively do away, in a sense, with considerations of proportionality, because they'll be fixed.
Sure.
You'll just have to fit in with it. But what it won't do is stop what I'm afraid old-fashionedly call solicitor-owned client costs. It won't stop people charging their clients more than the fixed costs, I suspect.
Won't stop the clients being willing to
or willing to pay it.
Spend more.
As I said, I used to have to meet Rupert Jackson a lot. My room was literally right above his. And the first time I ever met him on the subject, I said, look, you won't really get control of costs unless you control solicitor and client costs as well. Couldn't possibly do that. Parliament will have to do that. So I said, well, the rules will go through Parliament. But I got a stony stare at that stage, not surprisingly. I mean, I knew what he meant. You know, the profession would never stand for it, and so on and so forth.
Excellent. Judge Peck, let's take it back across the Atlantic. And what you see on the screen here is the six-pronged tests for Federal Rule of Civil Procedure 26B1. This is basically the six-pronged test to see if something is proportional. Now, it looks pretty reasonable. The issues at stake, amount of controversy, the party's resources. However, at the time of the passage, this, along with some of the sanctions found in another rule, 37E, were highly controversial. And in fact, in hearings before the US Congress, the title of the hearing was, Changing the Rules, Will Limiting the Scope of Civil Discovery Diminish Accountability and dun 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 dun, Leave Americans Without Access to Justice? And the title of the session is somewhat hyperbolic, and I'm sort of making fun of it, but there were concerns, especially from interest groups, that such things that sound reasonable, as these tests, fixed cost, et cetera, were really going to deny people justice and access to the truth. Judge Peck, what do you think?
I mean, that certainly was a concern. Now, obviously, one of the big differences between our practice and the British practice is, except in certain statutory cases or where it's a breach of contract dispute and the contract has a loser pays the other side's attorney's fees, each side is paying its own attorney's fees. So from the defense perspective, the argument was costs of discovery, particularly eDisclosure, were out of control, particularly in asymmetric type cases where it's a single plaintiff with very little data who could use discovery and the costs of it to convince, or some would say blackmail, the defense into settling because it was cheaper to settle than to incur the costs of discovery. And one of the issues, and that's why the importance of the issues at stake was moved to the front of the list of factors, was, well, what do you do with a case where there may not be as much money involved, but where there is a societal interest in the litigation? So, for example, a civil rights case, or by congressional enactment, employment discrimination, or any discrimination cases. So it might be a single plaintiff in a low-paying job, but who is suing for being fired, for any protected classification. Should the fact that they were fired 2 years ago and lost 2 years of pay that might have been, $50,000 a year, mean that the case is some proportion of $100,000, and therefore is not going to be very much discovery because you can't do discovery that cheaply. And so, no, the importance of the issue was put in for that. But all of this, in many cases, comes down to the last factor. It's the balancing test of whether the burden or the expense outweighs the usefulness or benefit from the discovery. And Microsoft, in the congressional hearings, had this great funnel demonstration that said, they spent X amount on putting in legal holds, and then another huge amount in producing, and how many documents were held, how many were produced, and then you get to the bottom of the funnel, and it said 50 documents were used at the trial, and why are we spending, all these millions of dollars to come up with 50 documents? To which, the wise rear end on the other side would say, well, just give me the 50 documents that you know are going to be my trial exhibits that are really bad for you, and we won't ask for the rest of it. That's one way of getting proportionality, but we rejected that approach many years ago. So it's a different situation because in most cases, each party is bearing their own costs, and so it's an attempt to get increased judicial supervision to keep one party from imposing outrageous costs on the other, or to convince parties to be much more efficient, as Stephen was saying, in how they do discovery.
You know, you see this list, and these are challenges. If these things were easy, they would have been decided long ago. And in our kCura relativity educational programming, we make a promise to you that we're not here to do sales pitches, we're here to give you useful information. However, having said that, we segue to our next topic, technology-assisted review. And obviously we have Judge Peck here, who is perhaps the foremost authority from the bench on this. But notice the title here, Proportionality in Practice. And former Senior Master Whitaker hit on this earlier. One of the great ways you can address these issues is with, lo and behold, technology-assisted review. And if you read the Piro-Pyro decision, you'll note that as much of a technology-assisted review decision, that's a proportionality decision. Read that decision, and it's really about proportionality. Are we all in agreement, starting with Judge Peck, that that is really about proportionality as much or not more than TAR?
Proportionality and efficiency. I mean, there are lawyers who say, I'm not comfortable if I haven't put eyes on every document. That was great when I started practicing back in 1978, and maybe there were 1,000 documents in the case, and I was one of those who felt like I needed personally to read every document. You can't do that when you're producing 1 million emails. And so the old idea that eyes-on review is the gold standard has been clearly disproved in scientific studies, and TAR is found to be more efficient and cost less by many, many factors than eyes-on review or keyword review.
You know, one thing, before we pass it over to the English side of the aisle, Judge Peck has talked about this before at Relativity Fest, and that is the number of cases where TAR is used versus the number of reported decisions that you see. And I'm going to borrow a line from my colleague Constantine Pappas because it's such a beautiful line. He touched on this morning, and he's talking about the fact that, someone wants a court certification that TAR is okay. And Constantine's response is, well, gee, pardon me for not getting sued. Stephen Whitaker, when you were on the bench, did you see a lot of TAR being used that perhaps never ended up in a reported decision?
Well, you certainly heard about it a lot. And I'm sure that for about 5 years before the Piro decision, it was being authorized by High Court judges, particularly in technology and construction in the Chancellor Division. I remember one famous conversation, in fact, when Andy and I were in Australia at one point with a practitioner who was doing a case back in the Chancellor Division, asking our advice on how he could, what resources he could use to show that TAR was actually better, generally speaking, than eyes-on review. So undoubtedly it was happening. The problem was that there wasn't a written decision. Now, Piro, in fact, and when you couple it with the David Brown and DCA case, is a godsend, because it gives you the hat peg to hang the hat on. You don't have to reinvent the wheel every time now. You can refer to a decision, albeit an interlocutory decision. Not that there's anything wrong with that, because, of course, as we know, the settlement rate of claims in this country is 96%. So actually, the interlocutory judges do the vast majority of the work. And I would say the most important part of it, they're the ones who are pushing cases to settlement rather than trial. So it was vitally important to have a case like that. And most particularly, if you look at both of them, not just proportionality, but its cost. The argument that was being put forward in one of the panels this morning, that, oh, well, clients will often say, well, you know, this is going to cost me a lot to use this technology review. I have to pay people like kCura an absolute fortune. No, that's not the case. What you've got to compare it with is what the cost of eyes-on review is. The more worrying thing about eyes-on review, not just that all the research shows that technology assisted review can be more accurate, is that there were still people arguing. I mean, look at the Digicel case. I think it was also argued, it was the basis of the argument in Quinn, wasn't it? That not only was eyes-on review the best way of doing it, but the law required it. In other words, the rules required you to look at every document before you could say you'd done a reasonable search. Digicel, the side that lost, was saying that. We've moved on, and these cases are, you know, the benchmark that is now set, that we have moved on from that. And finally, on that point, David, thank God, in both cases, and generally speaking, no one is suggesting that you need to go under the bonnet of the car and look
Thank
at
you
how...
for putting it that way, sir. There was a
how-
garment used many years ago, and I think we're all tired of hearing it.
Yeah, I mean, you know, you've got, with tar, you've got to take the view that it does what it says on the tin. You don't need to look at the algorithms. When I was doing the High Court judge training material, one of the judges I was speaking to in the Technology and Construction Court, and it would be that court, wouldn't it, said, oh, well, I really would need to know what the algorithms were doing in every case. Oh, my God, no.
Does he check the engine on the airplane before flying somewhere?
Well, I used the car. I said, look, if it's got four wheels, it's covered in metallic paint, it drives along the road, and it doesn't use a lot of fuel. It's a car.
And would you understand it if it was explained to you anyway?
Yeah, I mean, you know, you don't need to find out whether it's got 6 cylinders, 7 cylinders, 3 cylinders, or whatever. It's really important. And I was very concerned. You'll see on the bottom line there, Australia, you'll see a case mentioned called MoneyMax. Can I advise all of you in this room, don't look at the order in MoneyMax. Don't
Look at it, don't follow it.
We have a respectful dissent from the end of the dais.
One of the first thing on the list of things that was ordered to be handed over to the opposition by those people who wanted to use TAR to the opposition who didn't was effectively all the technical material about the algorithm and how it worked. Completely pointless.
Would you consider that to be work product?
Good question.
We don't
Probably.
I think
It doesn't matter
the
really.
same significance here as
It
work
doesn't
product,
matter.
really.
The bigger problem, I think, is in many cases, if you're really going into detail, it is proprietary to whoever is the source of that. So it's going to be very difficult. And I agree with Stephen, which is, I don't think that most of us who, you know, can barely count beyond 10 without a calculator are going to understand all the technicalities behind it. I would say, though, that what is important is, in any case, is not just, okay, whose TAR product are you using, but it's the combination of people, process, and technology that has to be considered. You could have the greatest TAR engine and have a very bad workflow or very bad decision-making on what is relevant and what isn't, and it's going to be a failure. So even if a court decision in a particular case says, you know, X vendor's product is acceptable in this case, I don't think that is ever going to be a blessing for the use of that product in every case.
But I mean, I'm not saying that you shouldn't, you are going to discuss the methodology. I mean, you are going to discuss whether you're going to use TAR 1 or TAR 2, etc., and how you're going to do it. That's all part of the process, and that's how you're going to get your protocol together so that, you know, you're both singing from the same hymn sheet and you know exactly what's happening. But to look at the technology of it is totally verboten. It would be used in every case. It would completely undo the not reinventing the wheel process. Every case there'd be an argument, or it would be used by people who didn't want to use TAR as a way of trying to undermine it.
Sure. Chris, I was going to ask you to add on to former Master Whitaker's comments on this. You'll notice we have the 4 flags here. It's not coincidental. These are the 4 nations that have approved judicially the use of tar, starting with the United States, rah-rah, going to Ireland, the United Kingdom, and of course now Australia. Chris, first of all, 2-part question. Number 1, do you want to lodge a respectful dissent to Mr. Whitaker on the issue of money max? And then secondly, what do you think is important coming out of that practice note from Australia in the Supreme Court of Victoria?
Can I just first whiz through the Irish one, and indeed Pirro?
Sure.
Of all those non-US ones, I think the Irish Bank Resolution and Quinn is the most important. And I say that because the test for whether you've done a good job in Ireland is very much higher. It's higher even than the US. You've effectively got to certify, if you read the rules strictly, that you're 100% satisfied that you've done 100% of the job properly. And when I first saw that 5 or 6 years ago, I predicted at a conference in Ireland, you will have trouble with this when somebody starts wanting to use technology-assisted review. The arguments were run, they were successfully run, and the court, using arguments of proportionality and what's reasonable and all the rest of it, accepted that the court had an inherent jurisdiction, whatever the rule said, to do what was right. And what was right was to accede to McCann Fitzgerald's arguments that technology-assisted review, or predictive coding strictly, was the right way to go. Let's just pause on that. Predictive coding and technology-assisted review are not synonymous terms. We've slipped into using them as such, and hitherto I've not cared very much, as long as you look at them, look at one or more of the products. I think it's time to start a fight back on that and drawing a distinction between predictive coding and the much wider concept of technology-assisted review. Pirro. Superficially, it all looks sweetness and light. The parties agreed. The judge put some nice words around it, including those neat 10 points. And there we have something that we can all look at. If you talk to, as I have publicly frequently, with the participants in that case, it was not all sweetness and light to begin with. There was an awful lot of dispute and discussion that went into what appears as a nice, friendly agreement at the end. And there's a lesson there, the value of getting in a room and talking and finding that there's more common ground than perhaps you thought, that a concession here is worth it in order to get a concession there. And they both the parties that I've talked to on that, RPC and Taylor Wessing, have kept at the forefront of the argument, am I doing the right thing by the client, as well as am I doing the right thing by the rules? And we reached that agreement, which Master Matthews expressed extremely well. Moving on from that to money max. Yes, it is possible to construe the first couple of points in the money max judgment as meaning you've got to understand the technology. I'm not sure that's the point. The point is the judge felt it necessary to inform himself what was going to happen here, what the parties were proposing to do, specifically what the party using predictive coding was intending to do, and sent them away to deliver a report. He said, the respondent is to provide the applicant a report from the provider and or the respondent's solicitors describing with particularity the manner in which the respondent has applied technology-assisted review for the purposes of giving discovery. So he wanted to know, if you're going to ask me to make a decision on this, I want to know something at least about how you're going to do it, what you're going to do, what the protocols are. Yes, it is possible that one or two of those go a bit far in asserting the need to understand the technology. The principle, however, of a judge saying to the parties, come back and tell me properly what it is you're asking me to make a decision about has got to be the right one. So whilst I don't disagree about that extreme point, the concept of requiring articulation of the pros and cons has got to be the right one. That's what McCann Fitzgerald did in Irish Bank Resolution. They delivered some very careful, thoughtful analysis of what was to be spent, what was to be saved, what would happen if it was done a different way. And the key word for the moment, if my key words for last year were RTFR, as in read the something rules, I think this year it's...
Read the federal rules.
Read the
I
federal
don't know,
rules.
you don't have federal rules.
Anything you like, flipping rules.
Your language cleanup service is here.
Yeah. If that has been my motto hitherto, I think articulate is my motto for the moment. Be willing to describe what you're going to do, what you're going to achieve by it, what you're going to save by it. And that's good old lawyering, really.
Indeed. This conversation on proportionality and TAR is a great segue into our next topic, the kumbaya world of cooperation. But before we get there...
Before you do, can I add something?
Certainly,
on
as
TAR?
always, Your Honor.
And, one of the problems in the United States, one of the things that I think slowed down adoption of TAR, besides that lawyers get paid by the hour if they're being inefficient, was the concern about judicial approval and some of the issues that were being debated in the cases about the seed and training set and how many rounds of training and things like that. The technology has moved beyond that. We are now in what the blogosphere calls TAR 2.0, which is largely using continuous active learning, where there isn't a single training set. In other words, TAR 1.0 was you go through a process to train the algorithm, and when you thought the algorithm was fully trained, that was it. It then ran through the entire corpus of ESI and ranked them, and that was the end of it, which meant that what was being used to train the system was vitally important. Continuous active learning means every document that is reviewed retrains the system. So it doesn't matter what the first few documents were that trained the system, because if the next document shows that X is important, the system will know X is important and bring back that among the responsive documents. So I think the change in technology has eliminated some of the holdbacks to using it. And I was very pleased in the morning session that Constantine was moderating, the number of hands here that went up saying that they had used one form or another of technology assistance.
David, we've moved on without mentioning the Victoria practice note.
Please do. I'm going to go back.
Yeah, very briefly. State of Victoria in Australia has a new practice note which came into effect in February, which covers a wide range of the use of technology in litigation of one sort or another. But it also says this, or specifically says this: in larger cases, technology-assisted review, I think they mean predictive coding, but they say technology-assisted review, will ordinarily be an accepted method of conducting a reasonable search in accordance with the rules of court. So there is the only example expressly set out in a practice note asserting that technology-assisted review, predictive coding, will ordinarily be acceptable. And that, I think, is a standard that the rest of us will pick up.
And since we don't have a similar rule in our federal or state rules, as far as I've gone in the Rio Tinto against Vale case in 2015, looking at the 25 to 50 cases in the United States and abroad that had approved of predictive coding, I went so far as to say that in the United States, it's now black letter law that if the responding party wishes to use predictive coding, the court would approve it.
With all due respect to you, and boy, I'm going to get myself in trouble now, I wrote shortly thereafter that if you have a jurist on the line of Judge Peck, that maybe that's true, but there are some judges I don't know would go along with that, especially then. Do you think in the past year and a half, maybe more, have come to the moment where they're along with you?
There are some judges who think that the Bakelite telephone is a dangerous innovation.
Yeah, I think there are some whose knowledge of technology is such that it's sort of, press the Staples easy button or whatever is the equivalent commercial here, and everything will be fine. There are some judges who think that if you don't put eyes on every document, you're committing malpractice and violating the rules. But I think there's got to be education of the court, but I think in general the tide has turned and that almost all judges are going to accept TAR, whether it's fought about, certainly if the parties agree to it, they're not going to interfere. And even if one party is objecting, if presented correctly, I think it will be approved.
Great. We're going to wrap with cooperation and then some closing thoughts, but I wanted to give you a chance to ask some questions if you have any. Are there any questions out there right now before we move into cooperation?
The only problem is we can't see, but that's...
That's true, but our great kCura team is here. Thank you, Ms. Aronian.
I'm sorry, Thornton. Chris, you may recall we worked together on the TCC guidelines for disclosure. I'm currently working on the working group that's rewriting CPR 31 for the UK. And Lady Gloucester's leading that. And we very much modelled the EDQ 2.0 on the Victoria practice note. So we will also be mandating the use of predictive coding technologically assisted review. It's going to dramatically shift the burden of responsibility and also make it effectively the de facto standard that you should be using technologically assisted review unless you can defend it otherwise. Sorry?
Presumably not necessarily make it the standard that you should use it, but you should consider
There
it.
will be a presumption in complicated matters that you should be using it, and you will be obligated to defend the choice not to use it in the future.
Yeah.
Hear, hear.
Yeah, excellent.
Excellent. On the issue of cooperation, you see in this cartoon that Tom Fishburne wrote a series of for years that really capture eDiscovery and eDisclosure. All we are saying is give peace a chance as they go to the court, and then you see the briefcase, make Sedona, not war, which segues nicely into the Sedona Cooperation Proclamation and also Hiles v. City of New York. This was one of Judge Peck's cases where a lack of cooperation really did a number on the use of tar. I know it perhaps is still an appeal, still an active case. Can you...
Settled as in most cases.
Excellent, so you can speak freely. What role do you think cooperation plays in tar today?
Obviously, if the parties are cooperating with each other, more likely that they will be that one side or the other will be using tar. In Hiles, it was the peculiar case where the plaintiff wanted to force the City of New York to use tar, and the issue came before me, a well-known tar advocate, and the city was saying, no, we don't want to do it. And I'm like, tar is much more efficient and cost-effective. You sure you don't want to do it? And trying to put my thumb on the scale. But essentially what it came down to is they were saying they had so many disagreements with plaintiff's counsel in trying to work through keywords first, which is the approach they wanted to use, that they felt that if they switched over to tar, they would never get agreement from plaintiff's counsel, and they would just be fighting about, the various aspects of tar. And as much as I wanted to force them, despite that, to use tar, and as I say, I tried very forcefully at the oral argument on the motion to say you really should use tar, I ultimately came out agreeing with the Sedona Conference Principle number 6, which says that the producing party is in the best position to decide what method it is going to use to fulfill its obligations. And based on that, it was, well, if the city wants to use keywords, so be it. They then settled the case. And it may come to the point, the difference, I think, is there it was the city spending its own money. Under the British system, where costs would be a factor, and I know Chris blogged about this and said, what would a British judge do in that situation? It might well be possible to say, you got to use it, or in any event, and I think this is where I would have come out, if the cost recovery issue ever became a factor in the case, which is you can't say something is too burdensome to do, or you can't argue later that you want to get all your costs reimbursed for lawyers reading documents ad nauseum if there was a better way to do it and you chose to ignore it.
On that better way to do it, it's interesting. I've always maintained that, especially in the world of technology-assisted review, there's more than one way to crack a nut. In fact, we were really pleased to have Sean Dougherty of 451 Research here as a speaker today. And when I was at 451 Research as analyst and counsel, I specifically called it Assisted Review Technologies, plural. Part of it was because I was getting too cutesy, wanted to have the acronym ART. But part of it is that there's more ways to do this and more different technologies. And Judge Peck mentioned Cal. I think Andrew is going to be talking very shortly about some of the different options that you can use when you're doing technology-assisted review. But cooperation then, it's still, a part of the process, but it's not going to really kill tar, usually like we saw in Hiles.
Correct.
Excellent. Some closing thoughts. Best practices, closing thoughts, some advice here from the podium. Why don't we start with Chris Dale?
Well, I'll repeat RTFR anyway. That's got to be true, and we're hearing in the US as well an emphasis on just what do the rules say. And if you look at one or two Court of Appeal decisions, look at the Court of Appeal in Shah against Lloyd's Private Bank, articulating something that is clear and on the face of the rules, but which nobody had articulated quite as well. What do the rules actually say is the first point, but the secondary is the other point I made about articulation. You can't articulate until you understand yourself, and that's the great quality that we need now.
Former Senior Master Stephen Whitaker.
I think try hard to make disclosure work in our system, because if you don't, they will water it down, and particularly people who represent plaintiffs, sorry to use that, I'm copying that from Judge Peck, will lose out. I'm hearing disturbing things about proposals to change the disclosure test in this country to a sort of bipartite test, basic and more advanced, which worry me enormously, because if you have to do that to get disclosure under control, you're effectively, potentially, giving people an incentive not to disclose things that they should do. We don't want to go back to those days. People like me who started at the bar in 1973 will live through all of that, where people did their darndest not to disclose things that were bad for their case, and we don't want to go back to those days. So try, for Christ's sake, to make disclosure work.
And United States Magistrate Judge Andrew Peck.
Needless to say, I'm a big advocate for the use of technology, and particularly, at the moment, predictive coding. I was asked at a panel at Legal Tech a few years ago, predict what's going to be happening in 10 years. And I said, well, in 10 years, everyone is going to be using predictive coding. And the reason is there'll be something better out there that they're too conservative to use. I want to be clear on that never means you're not actually looking at the documents you're producing. Some people said, I got to at least see what I'm producing. Well, yeah, the predictive coding assumes you will review what is being produced. The money saving will be in all the junk that you don't have to review that might be a false positive if you were just doing keywords. And finally, cooperation doesn't mean capitulation, doesn't mean giving over, the crown jewels when you're not required to. And whether this is coming from the client to the solicitor or the solicitor to the client, one way to look at it is, here's the bill without cooperation, here's the bill with cooperation, which do you prefer? And I would hope that most lawyers who are looking at the long-term client relationship, and certainly most clients, are going to pick the cooperative, less costly approach.
Thank you, Your Honor. Andrew is going to be coming up very shortly to show you how you can put some of these legal concepts we've given you to work in your daily practices. I hope this has been helpful and informative to you. And on behalf of our partners across the world, many of whom are in this room, the over 700 kCurians who make all this possible, please join me in thanking Chris Dale, Stephen Whitaker, Andrew Peck.